Welcome to the Employment Law and HR Podcast with your host, Alison Colley.
Hello and welcome to this episode 196 of the Employment Law and HR Podcast. I'm your host, Alison Colley. I'm an employment solicitor and HR specialist, and I run the firm Real Employment Law Advice, where together with my colleagues we provide advice and assistance to both employers and employees. Now, for those of you who are regular listeners to the podcast, I must apologise for the August hiatus on the podcast. I hadn't mentioned it in the last episode, but as it turned out, because of annual leave and being busy and school holidays and all of that sort of thing, I wasn't actually able to record any episodes over the August period. So I decided to have a break and to bring the podcast back to you now with the regular fortnightly schedule. So this is episode 196, and whilst I was having the break from the podcast in August, it was actually the 8th anniversary of the podcast starting. So I started this podcast in August 2014, and I started with 4 episodes initially I launched with, and it immediately went into iTunes New and Noteworthy at the time, which was really fantastic. I think it was due to the fact that there were a lot fewer podcasts, but of course it was great quality content for those of you who might have listened back to the episodes 1 to 4. So it was a anniversary moment in August, and obviously we're now at episode 196, so it won't be very long until we get to episode 200. So I hope you still manage to find value in these podcasts and that you're enjoying the content. And as long as you continue to listen, I will continue to record them. So without further ado, I'm going to get into this week's featured content. So this is the 6th episode in this mini-series around how to manage a claim in the Employment Tribunal, or a defence if you're defending one. I've covered off in the previous episodes all the steps up to witness statements, and so in this episode I want to just cover off some final points around preparation for the final hearing. Now, there are a couple of additional things that the Employment Tribunal may order you to prepare in advance for the hearing. And these are normally undertaken by the respondent, so the employer, person defending the claim, if they're ordered by the Employment Tribunal. But it may also be helpful, even if they're not ordered by the Employment Tribunal, to prepare them yourself, whichever party you are, whether you're bringing the claim or defending it, as it will ultimately assist you in preparation for the final hearing, but it could also assist the Employment Tribunal. And that is a couple of things. The first is what we call a cast list. So in a case where there are lots of parties involved or there are complicated facts over a long period of time, the Employment Tribunal might order you to prepare a cast list. And this is all of the people that are involved, basically, their role, their job title, so that it's easy for the Employment Tribunal to understand who's who. Now, again, you might not be ordered to prepare this, but you might think, actually, it would be helpful for me to understand who everybody is when I'm preparing for the final hearing. And also I could perhaps provide a copy to the other side and to the Employment Tribunal to assist them. The second thing you might get asked to do is to prepare a chronology. And again, this is something that the Employment Tribunal will require where there are complicated facts or, as I said, things have taken place over a long period of time. And so a chronology is exactly as a normal chronology is, so with the dates and then the events that have taken place. Now, sometimes what can happen when it comes to preparing a chronology, especially if the Employment Tribunal have ordered it and they've ordered the respondent, so the employer, to prepare it, it can become quite contentious about what's included. Sometimes one or the other party will want to include things that aren't really relevant or not covered off by the evidence or the legal issues, and it can go backwards and forwards. And I've seen often, actually, with chronologies, more dispute over the chronology than there has been over the bundle on what's included in the evidence. As well as disputes about what's actually included in the chronology, there can be disputes about the wording that's used. So if you are preparing a chronology for the Employment Tribunal, my advice is to try to keep the wording that you use and your description of events as neutral as possible. It's really tempting to state the events that took place in the way that you perceive them and the way that you are putting them to the Employment Tribunal. But again, to save yourself time and hassle, if you can be as neutral as possible about the events in the chronology, it will help you in the long run and save you time and stress in trying to resolve that. The other thing I wanted to mention that may be required by the Employment Tribunal is written submissions. Now, these are normally only ordered by the Employment Tribunal where both parties are legally represented. So this is where the parties' legal representatives set out in writing in advance what the key points of their case are. So if you were summing up the case, what are the key points? And again, you won't need to do this if you are representing yourself. It's unlikely the Employment Tribunal will order that you do that. But if you are legally represented, then you may hear the words written submissions, and that's exactly what it is. Now, it can be helpful, however, when you're preparing for the final hearing, particularly if you're representing yourself at that, to prepare your own written submissions. Not necessarily that you're going to give to the Employment Tribunal, but that you would summarise your case and the key points that you want to put across to the Employment Tribunal. When it comes to representing yourself in the final hearing, it's critical that you have a good understanding of the main points of your case. Now, obviously, if it's a case you're bringing or you're defending yourself and you've been representing yourself throughout, hopefully by this point you have that. But really putting it in writing in advance so that you can refer to it during the hearing is very important. It's one of the key stages of planning for the final hearing, along with reviewing the witness statements and the evidence and deciding on the key questions that you're going to ask the other side in cross-examination. Now, what you should focus on, like we talked about before in previous episodes, is the real legal issues. Again, it can be really easy to go off on a tangent and start focusing on the things that you feel are important to you, the emotional issues. But actually what the Employment Tribunal will want to know is, how are you directing them to find in your favour on these particular legal issues? And so what you need to do is have in mind the law, the issues as they've been defined or set out and agreed by the Employment Tribunal, and then the evidence that supports that. Or if you're defending, the evidence that disputes the employee's evidence. And because you may be representing yourself in the Employment Tribunal, I strongly recommend that you have each part of your evidence under each legal issue to deal with, and you cross-refer to the various paragraphs either in the claim or defence or the witness statements and the various pages in the bundle of documents, and you have that set out very clearly in writing for you to refer to during the hearing. The last thing you want to do is to be leafing through the bundle of documents trying to find exactly what it is you want to refer to. The more you can know and understand the key documents and the critical evidence, and also know the bundle itself anyway, the easier it will be for you and the more convincing it will be for the Employment Tribunal when you are stating your case or your defence. So the three things that the Employment Tribunal may order for preparation, as well as the witness statements in the bundle, are the chronology, a cast list, and written submissions if you're legally represented. And they are three things that you might want to prepare yourself in getting ready for the final hearing, even if they haven't been ordered by the Employment Tribunal, and you just prepare them for your own records and your own preparation and to refer to during the hearing. Now, the final thing I want to talk about in preparation for the hearing is the bundle and what you do with the bundle of evidence. Now, often the Employment Tribunal will direct you as to exactly what needs to be done with that. And it's normally the responsibility of the respondent to prepare that and get it to the Employment Tribunal in advance of the hearing. Now, how that is done will depend on whether your hearing has been listed for a video hearing or an in-person hearing. Now, if it's a video hearing, then what tends to happen is the respondent is required to provide a hard copy to the employee, and then a copy electronically to the Employment Tribunal in advance. And that's normally shared by way of a link to a cloud-based system, so you can use Dropbox and that sort of thing. Due to the size of the documents, it's unlikely that you would be able to email that, and the Employment Tribunal actually say that in their guidance when they write to you. They say we can only take a certain volume of documents as an attachment, and therefore we recommend that you share a link to a shared server or somewhere that they can download it from. Now, if the hearing is in person, it used to be that you would just have to take along various copies of the bundle on the day and give them to the clerk right at the very beginning of the day in the morning to pass on to the Employment Tribunal. And then the number of bundles that were required would depend on the type of case and the number of people in the Employment Tribunal panel. So, for example, in a discrimination claim, you would tend to have a 3-person panel, so you would be required to provide 4 copies of the bundle for the tribunal on the morning. So that is 1 for each member of the tribunal and 1 for the witnesses. And they have to be clean copies of the bundle. But what I have seen recently is that even for in-person hearings, the Employment Tribunal are asking the parties to share the bundle electronically as well, so that it can be accessed electronically, and or if the case is converted at the last minute, for example, to a video hearing, then the bundle is available. Now, the best way of doing the bundle is to ensure that it is one long document with the index at the front, and then you do it in a PDF format. The simplest way is if you pay or upgrade to the next level of Adobe, and then you can add in page numbers, you can edit, and you can make it look nice and easy to review. You can also add bookmarks to make it easy to move from one area of the bundle to another. And this will aid the Employment Tribunal in dealing with it, and also you if you're using an electronic copy for a video hearing to represent yourself. Now, I did mention then about the possibility of cases being listed as video hearings and or being listed as in person and then changing to video hearings. Obviously, since COVID, the use of video hearings has increased considerably. Whereas pre-COVID, it was very rare to have a all video hearing. Now this is becoming more commonplace, and the parties are normally being asked in the process of preparation whether they would be prepared to have it by video or in person, or what their preference is. You don't always get your preference, but it's important that if you are asked what your preference is, that you say. And if you have no ability to access things via the internet, or you have really ropey internet connection and you think, actually, I'm not going to be able to facilitate a video hearing at home myself, and I've got nowhere to go to do it, then you should let the Employment Tribunal know that it's just not going to be possible for you to do that. So to round off this episode of the podcast on the final stages to get you to an Employment Tribunal hearing, if you're representing yourself in either a claim or defence, it's important to really ensure that you are prepared, that you have access to all of the documents, and that you know how to share those with the Employment Tribunal, and how you're required to share those with the other party and the Employment Tribunal, as it may differ depending on the type of case that you have, or whether it's in person or via video. As always, if you are bringing a claim or defending a claim in the Employment Tribunal and you're having any problems at all, or you have any questions about anything we've talked about in this episode of the podcast, please don't hesitate to get in touch with myself or one of my colleagues. We'd be very happy to help. You can email, it's alison@realemploymentlawsadvice.co.uk, or you can telephone our office on 01983 897 003. And my colleague Kathy, who deals with our administration, will be happy to direct you to myself or one of my colleagues, who would be very happy to chat with you. Thank you so much for listening to this episode of the podcast. I will be back again, I promise, in 2 weeks' time with the next episode. And of course, if you've got any feedback, any questions, or any ideas or topics for the podcast, don't hesitate to get in touch.
Thanks again for listening. Just want to finalise by saying I wouldn't be a lawyer unless I had a legal disclaimer. So I must just say to you, that the information in this podcast is for information only. It's general review and a general update. It's always necessary to get specific legal advice about your circumstances. So please don't rely on anything that you've heard in this podcast. But please do feel free to contact me if you'd like further information or specific advice.